Okay, good afternoon, everyone. So we're all, of course, in cyberspace, but we're also on solid ground. And I think most of us are on the land of the Wurundjeri people of the Kulin Nation. And I want to give my respects to all of those people, their elders and leaders, and to any First Nations people in the audience today. This is the 8th of a series of masterclasses that have been brought to us in part by the circumstances we're all in, but I hope this will continue. And today, or this year, we've also, separate from the pandemic, been very lucky at the Melbourne Law School to have 3 new appointees in criminal law, all stunning appointees, and one of them is Amanda Porter. You can read all of their biographies on their law school pages, but Amanda has just asked me to simply say that she is a senior fellow at the law school. So Amanda will be leading a panel today, and I'll hand over to her to run that panel.
Hi everyone, I'm on the lands of the Gadigal Wongal people of the Eora Nation, and I'm honoured to be hosting this forum on policing the police, police powers and the rule of law, and police misconduct law. To discuss these issues, we're very fortunate today to have a panel of distinguished guests. Crystal McKinnon is a Yamatji woman and is currently working at RMIT as Vice Chancellor's Postdoctoral Research Fellow. Tamar Hopkins has practiced police misconduct law at Flemington and Kensington Community Legal Centre, where she founded the Police Accountability Project. And Jeremy King is principal at Robinson Gill, where he leads the firm's renowned police misconduct team and is responsible for extensive advocacy for police reform and oversight. Now, most of you in the audience through your JD and LLM courses would be very familiar with such concepts as the separation of powers and the rule of law, the idea that no one's above the law and everyone's governed by it. But what about those who enforce the law? What rules, laws and regulatory frameworks govern the police and police misconduct? What are the accountability mechanisms if a police officer breaks the law? And because the police are given special powers, such as the power to arrest, detain and use force, what are the mechanisms to ensure that this power is kept in check? To Tamar, because you've had extensive experience practicing police misconduct law at a community legal centre for 11 years. I was wondering if you could we could start by maybe asking you to give us a sense of the day-to-day nature of this work. I'm particularly interested to know what numbers we're talking about in terms of how many complaints you might receive at a community legal centre, what was the nature of the complaints, and I guess a sense of the complaints that are worked up and submitted, what proportion of those are successful?
Yeah, so difficult to answer all of those questions. I'll have a go responding in this way. When I started work at the Flemington Legal Centre in 2005, I had no police accountability experience and was coming in with sort of tenancy and welfare rights experience. But that was absolutely the key issue that was demanded by the local community. We had streams of young people, mainly African, some Afghani youth coming through the doors with incredibly similar stories about being stopped constantly, being searched, being asked for their names and addresses. People were describing being hit with torches, being hit with batons, having their mobile phones taken from them, having to prove that they own the mobile phone, like they could only get it back if they could provide the receipt. A whole being hit if they didn't provide their friends' names and addresses. There was also people talking about police raids going on inside their houses where guns were being produced, and they're, with young children inside the high-rise flats. People talked about being humiliated and degraded, being racially vilified, having their Qurans thrown on the ground. There was a story of a young man who was assaulted by the police and was lying in the ground with a police officer with his foot on his head, smoking a cigarette while waiting for a divvy van to arrive. So, these incredibly degrading, humiliating experiences. There were also assaults inside the police station, inside police, the interview rooms and inside cells. In one of these assaults, a youth described losing consciousness because the level of assaults was so great. So very highly traumatised community, a large number of people coming in to tell their stories, only a tiny fraction of those crystallised into complaints that were then provided to the Office of Police Integrity, which was the oversight body at that point. So over that first year and a half, 19 formal complaints went in to the Office of Police Integrity. We were asking for the Office of Police Integrity to investigate, but they referred all of those complaints back to Victoria Police to investigate, and all of those matters came back largely unsubstantiated. So we had fractions of matters substantiated, such as failure to call medical assistance in a timely manner may have been substantiated, and a couple of technical deficiencies in the way that the police had filled in their forms may have also been picked up. But by and large, the assaults, the racist humiliation, all of that conduct was not substantiated by the police investigators. Got a lot I can say about that process, but I'll just continue with the sketch. Alongside the complaints that we submitted, the young people were also charged by the police. They were charged with resist arrest, assault police, hinder police, offensive language, failure to provide name and address, the whole kind of battery of charges. And we ended up spending a lot of time doing defence work in the Children's Court and the Magistrates Court and on appeal in the County Court, defending those young people. And quite interestingly, in 10 of those cases where we were able to get the charges dismissed by a magistrate, having heard all of the evidence, there was also a police complaint that had been submitted that was unsubstantiated. So it was really clear to us to see how this independent process, having heard the evidence, having listened to the witnesses, was able to come to determinations that the police were engaged in unlawful behaviour, in sharp contrast to the police investigation process where none of these matters had been substantiated. So that was a really clear example of one of the systemic issues that we're facing. So and another interesting fact I'll just speak about now, in one of those cases, we discovered that a police officer had submitted two statements about what the events were. In the first statement, he had described our client's behaviour in a certain manner. Then after the complaint was submitted, he redrafted his statement to include all kinds of details about our clients being, engaged in violent assaults on that police officer. And in the courtroom, we were able to he accidentally brought both of those statements in. And so quite by a process of accident, we were able to see this before and after reporting by police. And I think that provides you with another example of how when police respond to complaints, they are quite prepared to distort and basically lie to cover up what actually occurred. So as well as those complaints, so I guess we were submitting complaints. We ran a major race discrimination claim as well on behalf of these young people. And at the same time, we're receiving complaints steadily in at the legal centre. And I guess while I was there, we were largely servicing the local community, but we then started attracting complaints from around Victoria, and it started getting quite out of hand, hundreds a year of complaints that were coming in. And we did an analysis that about 2% of those complaints that we submitted were substantiated by the police complaint body.
So about 2%. So in terms of why that number, and that's consistent with my experience at Redfern Community Legal Centre in the state of New South Wales, what do you think, Tamar, are some of the reasons why we see such small numbers? Is it a sense of, what kind of evidence is required to substantiate a complaint that you see in those 2% of successful cases, in your view?
Well, those that they were substantiated because there was evidence that couldn't be, like, it wasn't the police version. There was some kind of independent evidence that could be drawn on. But I think, I mean, what's really important to be aware of is that the people who are looking at those complaints, making decisions about them, are the police themselves, and they will view what is going on through their particular lens, and that isn't a lens that a civilian person would take to a complaint. So I think that's a really huge part of why complaints are failing, and that they simply rely on the evidence that police are providing without checking further. So it just, sometimes they require a statement from the police, sometimes they just go on the police notes, and they don't interrogate that statement. They accept the police evidence on face value, while our clients are treated as if they are criminals. They're making up a story to hide their own criminality. So there is a judgment that is very much made about the character of the participants in the complaint that goes very much in favour of the police and against our clients. So I think that's a big part of it.
Great, thank you, Tamar. Jeremy, thanks for joining us, and thanks for bearing patiently with us with these technical issues. If you could just give us like a very short summary of an overview of the current system of complaints in the state of Victoria.
Yeah, okay. So essentially in Victoria, if you have an interaction with the police and you consider there's an element of misconduct to, you can make a complaint in one of two ways. Well, actually make a complaint a few ways, but essentially the two main ways are to make it directly to Victoria Police, or you can make a complaint to IBAC, which is the Independent Broad-Based Anti-Corruption Commission. That name just rolls off the tongue. With Victoria Police, you can either make a complaint directly to the station, you can write to the Professional Standards Command, or you can write to the Police Conduct Unit. You can make those complaints online, but essentially in Victoria we have a two-tiered system. One is IBAC and one is Victoria Police, but IBAC only take a very, very select few of complaints. So they refer over 90% of complaints back to Victoria Police to investigate themselves. But yeah, that's essentially the complaint system we have here.
Great, thank you, Jeremy. Now in 2018, I understand that in the state of Victoria, a significant report was released, the report of the inquiry into the external oversight of police corruption and misconduct in Victoria. And I understand that report recommended, among the recommendations that it made a recommendation for an independent system of complaints. And this is a question for both you, Jeremy, and you, Tamar. I understand that you both made written and oral submissions at this inquiry. And I was just wondering if you could tell us a bit about why you think this report is significant and what the progress has been, if any, in implementing the 69 recommendations since it was published 2 years ago.
You want me to go first, Tamar?
Sure, yep, why not?
So that inquiry was a long time in the making and came about in part because of people like Tamar pushing for it. So I just want to, acknowledge that from the get-go. I was very much standing on the shoulders of giants. And the submissions that we made to that commission and that were, that Tamar also made were really about the fact that we think that it was broken, that it wasn't working, and that there were a number of holes in the legislation as well in respect to IBAC in particular. And I thought on the whole, the report was pretty good. I was a bit surprised, maybe keep your expectations low. It was a bipartisan report and a few of the things that were good that it recommended was it finally gave a definition to what serious police misconduct was, which up until that point and still hasn't actually been defined in the legislation. And that's to really put a bit more rigour around when IBAC can refer something back to Victoria Police or not. It also was talking about putting in place a special unit within IBAC, because you've got to remember IBAC does all government corruption. So it doesn't just do police misconduct, it does everything. And what they were talking about in that report, they made some recommendations around forming their own police misconduct and corruption unit. So just a dedicated task force to be able to deal with police misconduct. And another thing of many, it's bloody tome. Another thing that they did that I thought was quite good as well, which was that if IBAC didn't take on a case, they would have to report every year back to government as to what cases they hadn't taken on and why, which was a nice little auditing system behind that as well. So those were three of the big things that they recommended in that parliamentary report, none of which have been implemented yet, which is obviously very disappointing. But yeah, Tamar, did you want to add to that?
Yeah, I guess I could just add a few things, and that is that sort of historically in Australia, oversight bodies have been more focused on police corruption rather than human rights abuses, and this is this pattern is not replicated around the world. It's quite a unique part of the Australian oversight sort of regime. And I think what it does is really devalue the experience of everyday Victorians, everyday Australians and their interactions with police. They totally go under the radar. And so, yeah, this report was really significant in that it was actually for the first time highlighting human rights abuses, police misconduct as being, that it should be of central concern to the oversight body. So that was a real first, I think, in Australia. But as Jeremy says, it's a bipartisan report which just simply has not been adopted. And I mean, it's interesting that we have, a Labor government that we would be assuming that would be more likely to take, implement such a report, but we're seeing absolutely no steps towards that. They have raised that, the Gobbo inquiry is what's keeping it on hold, but I think these are two very separate issues. Again, one is really about human rights abuses, whereas one is about other types of police corruption. So they don't need to be linked in the way that the government is doing. I mean, I'm quite cynical about what's going to happen with that report, despite it being bipartisan.
Great, thank you, Tamar and Jeremy. I'd just like to move now to maybe some discrete examples, just by way of illustration for the audience. And Jeremy, you've worked on a number of high-profile cases. One in particular in Melbourne, the raid on the community bookshop Hares and Hyenas last year. I was wondering if you could just briefly walk us through the history of this case.
Yeah, so that was a situation where. And I've got to be careful here because I'm privy to some documents that are not public, and I'm talking to law students. So I don't want to breach my Harmon undertaking. Essentially, though, what happened with that case is that police raided the Hares and Hyenas bookshop, which is an LGBTIQ bookshop in Fitzroy on Johnson Street. They were pursuing someone they had been pursuing someone for a long time in a car. And that car had been dumped in an alleyway behind the bookshop. They went into the bookshop, and this was also the Critical Incidents Response Team, which is called CERT, which is a section of Victoria Police. They went into the bookshop, and then one of the people in the bookshop, there were three people living there. One of them, Nick Demopoulos, thought it was a home invasion, and he ran down the stairs and out the front, where he was captured by police, taken to the ground, and then effectively had his arm twisted behind his back and suffered a very severe shoulder injury as a result of that. There's going to be this is subject to Supreme Court proceedings at the moment as well, so there's going to be lots of, that's all right, there's going to be lots of discussion about it, but essentially that's in essence what happened during the Hares and Hyenas. IBAC did an investigation of it, so police started doing it, and then IBAC took it over. I thought that IBAC investigation was really pretty flawed, and I'm happy to talk about that for as long as you like. It was a weird situation to be in as well, because Tamar and I obviously are huge proponents of independent investigation. I mean, perfect world, all police complaints would be independently investigated, and this is one of the rare situations where it was, and yet they still stuffed it up. I say they misapplied the law in regards to when police can conduct a raid or when they can search a premises. We say that there wasn't reasonable belief. We also say that there was a massive hole in the IBAC case, well, not IBAC case, IBAC findings, in that they didn't obtain an expert report in respect to how the mechanism of injury occurred. So Nick suffered a really bad shoulder injury, but they never actually obtained a report as to how that shoulder injury occurred. And if you don't know when an injury occurred, how can you say that the force used was proportionate at that time? Because an arrest isn't a static thing. Like it might be okay at this point. By the time you get to this point, though, and they're restrained on the ground, then force is no longer required, and any force used after that is excessive. So the fact that they didn't get a report regarding how the injury actually occurred, to me, was a gaping hole in their findings as to the fact that force was somehow proportionate, because how can force be proportionate if you don't know when it was being used and how it was being used? So amongst a whole other bunch of other things, that was a bit of a problem. I think also, to be honest, in terms of the IBAC findings, it was a bit disappointing, actually, because there were two other residents there, Crusader Hillis and Roland Thompson, who gave their stories, and their stories aren't mentioned at all in any of the material that I've seen. And, you know, their evidence wasn't really taken into account. There seemed to be a sort of weighted given to the police as opposed to the individuals involved in it. There was also this sort of bizarre finding, which I'm sure Jeremy would be all over, to be honest, but this bizarre finding that they didn't tell him he was under arrest. And so there's a whole bunch of case law about when you have to tell someone's under arrest. There's a case called Lashinsky, which is sort of the leading authority of that, which says that it's not a valid arrest unless you tell someone as soon as you can that they are under arrest and why they're under arrest. So they sort of found that, but then still found that the force used was proportionate. So there was this massive disconnect in terms of the findings.
Great, thank you, Jeremy. And I did have some follow-up questions about the IBAC, but in the interest of moving on with time, I might save them till later. I wanted, that case of Hares and Hyena involving mistaken identity is something we see frequently in police lethal shootings and deaths in police custody. And some current examples include the police fatal shooting of Breonna Taylor, the African-American medical worker who was shot and killed in her home earlier this year. And also the case of Shadina Wynne, a 26-year-old Aboriginal woman who was shot by Western Australian police in April last year, the death of David Gundy, who was shot in a botched raid in his family home in Marrickville, among many other examples. Crystal, why are Aboriginal communities overrepresented in mistaken identity cases such as these, especially those involving life-threatening and fatal violence?
Just to start, I think that all interactions Aboriginal people have with police are potentially life-threatening and potentially fatal. You know, a lot of the deaths in custodies are a result of, you know, infringements or, you know, other things that you would think wouldn't result in some sort of a death, or it's not, you know, not necessarily raids or that sort of thing. It's the everydayness of policing practices, I think, which is the real, well, not the real, that's the violence is in the everydayness of it as well. You know, I think that there's, you know, there's a problem. I think it came out in the Royal Commission to Aboriginal Deaths in Custody as well, with the universal application of laws which are seemingly supposed to be evenly applied, but then we've got the individual people and individual police officers rather that, you know, they can act with racism and, you know, assumptions and stereotypes about Aboriginal people, you know, which is a part, I guess, from the systemic racism as well, in which they're acting within institutions themselves, which are racist as well. But, you know, and I think a part of the problem with, you know, these sorts of deaths that you're talking about, you know, think about Common J. Walker and others as well, is that I just think that police often see Aboriginal people as expendable and unredeemably criminal. And so they don't take care to ensure they've got the right person in custody. They don't take care in their interactions with people. They don't listen to people when people speak back. And, you know, then you end up with charges like Tamar was talking about before with, you know, resist arrest and all the rest of it. And yeah, and they don't listen. And then, you know, these sorts of, you know, people die, you know. And I think it's a broader issue of both systemic racism and individual racism, you know. So yeah, I think that's it's a big, I don't know if that's the answer, but it's
an excellent response. Thank you. I was also keen to get your opinion, Crystal, on the fact that the fatal shooting of Shadina Wynne took place in April last year, and there's lots of parallels with the case of Breonna Taylor, but yet, I mean, I was in Sydney when that took place in April last year, and it didn't provoke anything like the kind of response of mass protest that we've seen around the nation this year. Why do you think this is?
So that's another really big question, but yeah, I don't know. I'll just I'll start with, I guess, the media. I think that well, I think Indigenous people in Australia, we occupy. It's really hard to get issues up and get issues out there, and we're struggling with media as well, who are racist themselves as well, and they don't want to tell Indigenous stories. They don't want to highlight these issues, and it's really hard, I think, to get the stories out there and for it to be well known when, you know, the media itself are creating and purporting and circulating racist ideas. And I think the Kumanjay Walker case, again, I think is a really good example of that, as is Cameron Dormagee's case, but with Kumanjay Walker last year, you know, when he was killed by police, if you look at the media afterwards, it's like he's seen as aggressive, violent, irredeemably criminal, and all the rest of it. And then you've got the media working to humanize the police officer who killed him. And I'm not going to say his name, I think, because it's might affect the case or whatever, but you know, the media work to you know, they're humanizing him, they're painting him as a decorated officer, as a family man, as this is just an isolated incident in a stellar career and all the rest of it. And so I think the media really works to criminalize, to dehumanize, to do that sort of thing to blackfellas, where with the white people who are doing the murdering and killing and all the rest of it, or having these types of, you know, interactions with people, they do their best to just say this is an isolated incident, and rather than connecting it into this broader problem of police interaction across the board with Aboriginal people, you know, and seeing it as a part of a broader problem and a broader issue which Australia needs to reconcile itself with and really work to systemically change these, the criminal justice system, for instance, in order to not have these types of interactions.
Thanks, Crystal. I've got a question for Jeremy, moving on to another case involving assault and CCTV footage. I understand that you represented a disability pensioner in a case which some in the audience may be familiar with, that involved 6 Victorian police officers and a disability pensioner being held down in his front lawn in Preston in September 2017. Some might remember the footage of this gentleman being held down on his lawn and being sprayed with a high pressure hose, and another police officer also taking footage for whatever reason. I was just wondering if you could briefly walk us through that case and the outcome that you saw there.
Yeah, so that his name was John, and the police came to his house for a welfare check at the behest of his psychologist. He didn't really want to go with them because he wanted to deal with it on his own, and so he was then forcibly taken outside, taken to the ground, and then I've got to be careful because 2 of the officers have appealed their conviction. So I'm just going to use the words alleged, even though it's pretty clear in my view. Allegedly have assaulted him, and then he has then been pepper sprayed, and then while he's handcuffed and pepper sprayed, a high pressure hose was used to spray him in the face, and then one of the officers was filming it and got the other officer to spray him in the face again with the high pressure hose so he could continue to film it. and as a result of that, civil action was brought against the police, which resolved, and criminal prosecution was brought again by IBAC, and the 3 officers were found guilty. 2 of those officers, though, have appealed their conviction and sentence, so that is still before the court. But I think just picking on something Crystal said, which I thought was interesting in that case of John, the case of John's case is probably the most media interest I've seen in a police case in Victoria. It shouldn't be. There are many other cases that should have got that, but that is probably because there was vision, to be honest. And it's probably just an interesting side point in terms of when the media does pick up something and when it doesn't pick up something, is because there was this crystal clear CCTV and it was his CCTV. Very critical. It wasn't the police. This isn't body-worn cameras. This wasn't divisional, like divvy van footage. This was his cameras, and then that got into the media. And I think because of that, it created a bit of a media storm as a result of that, and it got a fair bit of traction in the media, and it was pretty hard for them to get around. But I think that's because there was vision, and also because it was his vision, if I can put it that way.
And I didn't realise that this was the case was being appealed, but successful police assault cases are very rare. What do you think was different about this case, notwithstanding that it's still in session? And do you think the outcome would be the same without this CCTV footage?
I think the outcome would not be the same without the CCTV footage. I think it is incredibly difficult to convince a court to convict a police officer in the absence of CCTV footage. Most cases that are brought by IBAC have, in fact, all cases that I can think of really brought by IBAC have footage. And I suppose very sadly the answer is no. I think it would be too high to get over beyond reasonable doubt, to be honest.
Okay, thank you. Crystal, you followed the case of Aunty Tanya Day since her death in December 2017, and you've worked as a support person for her family. Can you walk us through the history of this case and her family's fight for justice?
So I would hope that everyone watching is familiar, but I'll run it through. So on December 5th in 2017, Aunty Tanya was travelling from Echuca to Melbourne on a V-line train. She fell asleep on the train at about 3 p.m. and a V-line conductor woke her up and quickly racially profiled her, and he rang the police rather in Castlemaine, and he said, we've got a drunk passenger without a ticket. And then he's also said that she was unruly, lying with her feet blocking the walkway. Other witnesses who were on the train, and other V-line employees themselves as well, they all said she didn't appear intoxicated, and she wasn't unruly or anything like that. So at 3 p.m. at Castlemaine train station, Aunty Tanya was arrested for public drunkenness and taken to Castlemaine police station and placed in a cell. Straight after she was put in the divvy van, police were called to a local pub where a white woman was drunk and was unruly and was carrying on, and she was taken home, not put in a police cell at all. So when she was in the police cells, basically, she fell and had a cerebral brain injury. Sorry, I want to get the words right. Cerebral brain hemorrhage after falling in the cell, and the police basically failed in their duty of care. They didn't do any checks, or they did inadequate checks rather. And basically she ended up dying 17 days later in hospital. There are a number of points where the system failed Aunty Tanya, from the initial interaction of the V-line train to the various arresting officers to the officers who are supposed to be watching her and caring for her at the police station, to the ambulance officers who attended to later on in the hospital. She was failed at every point. It's horrifyingly, it's awful, this case. And her family have campaigned for a long time to get her to bring her justice. And basically, the directions hearing, they considered the issue of systemic racism, the coroner's court. So that was a part of their findings, or part of the things that they considered with all the actions of all the different points in the case. But they found that the V-line conductor's actions were racist and based upon her being Aboriginal, and that she would have been treated differently if she was white. And she also referred the case to the DPP for criminal charges, or to look at the possibility of criminal charges. The family have fought at every step of the way for justice for her and justice for others too. They successfully campaigned to bring an end to public drunkenness as a criminal charge in Victoria, but that's yet to be implemented or carried on by a big poll. But yeah.
Thanks, Crystal. And just a final question before I'm mindful to leave enough time for 15 minutes Q&A from the audience, but just we're so lucky to have each of you who have worked for decades extensively at the coalface of police accountability in Victoria and in Australia. What do you think is required to bring about change? I'm just curious to know each of your thoughts on this briefly. So big way to finish.
There's a multi-layered problem. As Crystal has described clearly, there's an issue with the media. There's an issue with the way our governments run law and order campaigns and support police powers. The way things that shouldn't be criminalised are criminalised. The absence of the accountability mechanisms that are in place are absolutely deficient, which means that police get away with breaking the law on a daily routine basis without any kind of oversight. So it's a massive issue, and it requires a lot more, a major shift in public sentiment around the role of police in our society and issues of racism and institutional racism. So it's a big one. Yeah.
Mm.
All right.
Yeah.
Oh, sorry.
Oh no, I mean, I don't know, Krista, did you want to say anything, or was that just for Tamar, or did you want me to add to that, or?
You go first, Jeremy, and then I'll quickly say something if you want.
I was just going to make one point, which is I heartily endorse everything Tamar says, and it is, I don't know, Victoria is this weird state in a lot of ways, in that we're supposed to be the Massachusetts of Australia, but when it comes to law and order, the Victorian government's response is just more PSOs, more police, more equipment, more powers. When the rest of the world is looking at defunding police, we're looking at, let's keep funding them more and more. And I just think, is that government? Is that coming from the union? And it's also interesting because I actually think there has been a bit of a shift in the community over the last few years, to be honest, in terms of, being willing to be a bit more sceptical about police, but that hasn't filtered through to government yet, for whatever reason.
Yeah, because the campaign to end public drunkenness run by the Day family, that was about having health responses instead of policing responses to the issue of public drunkenness, which is, what we're talking about when we're talking about defund the police. It's not about removing things. It's about, health responses and community responses in order to stop people having these negative interactions with police. But I did, apart from, if the negative interaction does happen, there needs to be full, transparent, independent investigation. David Dungo's family at the moment are running a petition in order for an Aboriginal-led investigation into his death in custody. I did speak to April about this question. So that's Auntie Tanya Day's daughter, about this question about what needs to happen. And she sort of spoke about the need for it. And, obviously I wholeheartedly support endorse this, but everyone needs to listen to families who've lost people in custody and listen to the families of people who suffered at the thing, and then also they need to act and support and, you know, support the things what families are asking for. You know, the most successful public drunkenness here, Miss Dew's family in WA campaigned for 6 years in order to end the incarceration of people for infringements. You know, the families who have suffered at these laws know what needs to happen, and we need to get behind it. And in order that, I'm just going to do a quick plug, because tomorrow, April's, there's a new foundation that the families of people that have died in custody are creating, and it's going to be about peer support for people who have, who do lose somebody in custody, and also advocacy work. And they're doing a plug tomorrow for at the Australian Communities Foundation. And the organisation, or the foundation rather, is called the Jarjawa Foundation. And yeah, so I get behind it and go and listen to the families of people that have lost people. And, you know, that's where the movement's being led by, and that's where activism needs to start. It needs to centre the families and needs to centre those who experience these violence and these deaths, and then move on from there and go with their directions.
Thanks so much to all the panelists and to Amanda for the questions. We've actually built up a very large number of questions from the students at the moment, or the attendees at the moment. So I'll just start running through those. So the first one I think is to Tamar, and it's about, you gave the argument for why we need external review. What is the police's argument for having internal review? And if I could add just a particular observation to that, I've often noticed that even when you have external review, the body is external, but when you look at the names of the employees of that review body, or even the heads of the bodies, they seem to be familiar names from within the police. They're often ex-police officers or police allied people, or connected in some way.
Yeah, I mean, interestingly, so the kind of the body that everyone cites when looking at, you know, first class independent investigation is PONI, the Police Ombudsman of Northern Ireland, and they have a rule that only 25% of staff are to be former police officers, and those 25% need to be outside from Northern Ireland, so not actually from the local area. So yeah, the reason that police argue that they should retain police investigations, I've heard, is that they view it as a management issue, that it's about like managing their members, and that, you know, they only police have the skills or capacity to investigate, and that you know, they know deeply how the systems work, and therefore they should do it. They're the only ones that can provide the kind of timely response. You know, it's only the police that can get to a death in custody straight away, not an external body. Now, all of those arguments can be are refuted by facts, by examples from around the world where independent bodies are able to get there straight away, where they are totally well trained to be able to investigate independently. But this concept of police, it being an employment management issue, misses the fact that these are human rights abuses, these are criminal offences, and that every other organisation would have an external body investigating those matters. So it just doesn't hold up. They're the excuses.
Okay.
Sorry, Jeremy, I was just going to say, you were bang on the money on that, and Tamar answered that beautifully, but that was actually something that when the Oversight Committee was writing its report, it focused a lot on, and I think it asked Tamar questions about that, and certainly asked me questions about that. And I said, well, you know, when lawyers come to work for me at the start, they might not know a lot about police torts, but you've got to train them up and bring them on board and that sort of stuff, because they're saying, oh, you know, it's so hard to find people to come work at IBAC. I said, well, you know, you do have to invest in it. You've got to give them the resources. You've got to train them up. You've got to recruit and do it properly. And that did seem to get some traction in the report.
All right. So the next question I think is for you, Jeremy. It's from Lucas. And if I could paraphrase it, it's about the Hares and Hyenas case and IBAC's finding. And the question is about how IBAC focused on just working out what the officer thought was happening, and not necessarily what the officer ought to have thought was happening. Is that a take you would have? And if so, how would we fix that, or what response should there be to that?
Yeah. I mean, I was pretty forthright in my views as to IBAC's understanding of the law when it came to reasonable belief regarding raiding a property and also regarding what is proportionate force. I think they got the law wrong, and that is pretty concerning. What I think should have happened in that case is they should have investigated it, because they do have the powers to investigate it, but I think they should have referred it to the OPP and let specialist criminal lawyers then analyse the evidence that they gathered properly. And that does happen in IBAC from time to time. That's not that's not an unusual thing to happen. But I suppose in a way of answering that question, I agree, and I think they misapplied the law. And I think they're not specialist criminal lawyers, and that's what should have happened in that case is it should have gone to the OPP.
Okay, so the next question is for Crystal, and it's picking up the issue of the rise of social media, which in part is about video being available on the web, but is also about who controls the media. And it's specifically whether the rise of social media, what your view is about the rise of social media as an alternative to the mainstream media in how these issues are dealt with.
I don't know if social media, these movements are completely reliant upon social media. I say that on the outset, and the organising and getting, getting messages out there. A good friend of mine who's a lawyer and that said to me about, if you want to make sure, if you're having an interaction with police, you go live on Facebook because it's there forever and they can't delete it. And that's, I can see Jeremy smiling at that probably. But yeah, so, like the social media is really important, but it doesn't replace the media and what their responsibilities are either. Like, it's not, I don't think we should accept that the way that the media operates in this country and that the power that they have to control messages, and, social media, like social media is incredibly important, but I don't think it should replace, the media. And I think something needs to change in this country regarding the way, the responsibilities of the media, I think, and the mainstream media.
So actually that's a perfect segue to the next question from Jamison, which is about where we should be directing our efforts, and should it be to these institutional reforms and implementing reports and the like, or should we be directing our efforts directly towards racism in society? I was wondering, Amanda, if I could put you on the spot on that. I'm curious about your view, but I'm sure everyone has a view on this one.
Yeah, I'd be curious to know what everyone on the panel thinks, but I don't see these things as being mutually exclusive. Like, I think it's important that there's, that we confront racism in this country and internationally, and that involves like having honest conversations about the history and contemporary practice of the police. And I think, we can have these conversations simultaneously with, while thinking about how we can institutional change or defunding issues, the need to, structural change as well, and that these conversations can and should take place simultaneously.
Any views from the rest of the panel on that?
I mean, I don't know. I completely agree with Amanda. I don't think it's mutually exclusive, and I think actually what works best sometimes is when you have different people approaching it from different angles. The two things that I know, staying within your wheelhouse is important. The two things I know I can do is I can sue the police and I can, try and generate some media, although that can be problematic. I accept that, but you can generate some media around it. That's the only time I've ever seen any sort of movement from government on that part. But you can't get around the fact that the incredible work that I think Crystal and Amanda and Tamar do in terms of academic research, academic papers, building up, because there's just not enough. I mean, traditionally there just hasn't been a lot of that, to be honest, in Australia. And I think the fact that you have great academics doing that great work in terms of building up that can also then be used to drive systemic change and advocacy, because at the end of the day, you can only make the arguments if you've got the academic research and the evidence to be able to push for it, particularly when you're trying to do radical things like say, well, hey, instead of buying the police new armoured vehicles, why don't we actually divert it into education? So I don't know. That's just what I think.
Actually, that
I want to add one more thing, and that is, yeah, it's about research, but also education. And on that point, I also just wanted to plug a poll that, like, it's always struck me as bizarre that you can do an entire law degree and that policing and law enforcement isn't part of the Priestley 11, for example, and that you can go through law school, and I think that's part of, and you can go through your entire primary school or high school education, and the level of ignorance about the history of policing in this country is, you know, research is one part, but another one is education. And on that point, I just wanted to say that, yeah, I think there's a responsibility for law schools and for, you know, all curriculum to teach about the true history and the current operation of policing. And on that note, part of the reason for this masterclass was, I guess, to gauge student interest in a potential elective on this topic. And I know that Dorothy's put together a little poll for me. So for of those people that have shown up today, I've put together a little poll. If you could just indicate, if you are so inclined, which of the following kind of iterations of this course you'd like to see at the law school. And if you wouldn't mind filling that in for me, that would be very much appreciated.
Yeah, look, it's one thing that's always interested me, apart from that issue of the Priestley 11 Australia, is if you compare us to the US, all law students learn about policing law in detail in first year, and the subject they learn it in is constitutional law. So that's another difference from us, but I completely agree. It's bizarre that policing isn't there in the Priestley 11. So look, while you all do the poll, there's a further question from Samantha, and this actually does ask something close to my heart, which is another element in the process of policing the police is prosecution. So there's a prosecution in the John case, and on the other hand, a prosecution hasn't happened in the tenure day case. Where do you think prosecution should fit in? Is prosecution a solution for this problem? And if not, where should prosecution of police officers fit into all of this? I think that's more or less a question for everyone, but maybe we could start with, well, I don't know, Tamar?
I think if that's what the families want, then that's what we should be supporting. If the families want the police to be prosecuted, then that's what we need to get behind. You know, the DPP were referred, the case of Annie Tanya was referred to the DPP to investigate criminal charges, and they didn't come back with, for an indictable offence for the police officers, and they came back with, they didn't do that. So, I think the family's exploring the next options for what they want to do, and whatever those are, we need to get behind.
Yeah, and I just want to mention that there's a lack of interest in prosecuting police. Like, I remember speaking to the head of the OPI at one point about how, why is it that they weren't, setting up more briefs, and they were just saying, oh, it's just too hard, it's too big, we can't do it. And whereas members of the public are prosecuted routinely for stealing chocolate bars. So there's this completely massive difference between what police have to do in order to get prosecuted versus what the public has to go through. So yeah, massive contradictions in where we as a society put our energy in. What is the bigger offence, the chocolate bar or the breach of human rights while you're in paid employment,
And Jeremy, look, before, I imagine you want to weigh in this too, given there was a prosecution in the John case. One of the questions from Cam is just noting that there was the criticism of the police, a very well-known phenomenon, that they get their stories settled in advance of any investigation. Just what are the barriers to prosecution? And you mentioned, of course, that there was a prosecution in the John case in part because of CCTV and media attention, and those two are linked. What are the barriers, and why aren't they happening more?
Yeah, I think, it's funny, there was actually an article today published by the ABC by Hayley Gleeson, which was about domestic violence perpetrators who are police, and how Victoria Police are dealing with that, which kind of dealt with all these issues. So if you're interested in it, you should definitely read that article. It's a really good article. And it's a really long-winded question as well. So I'm trying to think of it in a way of of making it tight. But historically, a lot of police haven't been charged, to be honest. And I think charging police has only been a very recent phenomena for two reasons. One, the government and Victoria Police have become sensitive to the issue of domestic violence and have seen that they have to do something about that because there was such a systemic issue within Victoria Police in terms of being perpetrators of domestic violence. So I'm not by any means saying they've gone far enough or they're doing enough or anything like that. I'm just saying that's one part of it. The other part is every single person has a phone in their hand. And nowadays, many interactions with the police are filmed, and it's always the ones that are filmed that tend to go to prosecution. So if you don't have that footage, in my opinion, you are going to struggle to get a prosecution, which isn't right. I completely agree with Tamar, it's wrong, but I'm just saying one good thing about the rise of mobile phones, and there are many bad things, but one good thing about the rise of mobile phones and CCTV is that that has led to a greater number of criminal prosecutions. But criminal prosecutions are highly problematic as a form of accountability because, you know, generally police get light sentences, it's beyond reasonable doubt, the person gets re-traumatised going through the process. I have always thought civil is better. You're not going to get a criminal conviction at the end of it, but in a civil proceeding, you control the process. You get to put the case how you want. You get to tell your story how you want. You get to push them for documents. You get to ask them for questions. They're the defendant. They're on the back foot. And I just think, by and large, that tends to be a much better form of accountability. I still think at the end of the day, and it's a sad thing to say, that civil proceedings is usually the only time where you do get to peel back the curtain and see what's behind the curtain and see who the wizard is.
I can't help but think of the recent mobile phone coverage of a protest at Sydney University, and one of the recent ones that got posted yesterday was of someone's mobile phone being taken from their hands or falling from their hands, and the final scene was a police officer's foot stepping on the phone. Obviously, it was still broadcasting or something at the time. Look, we've hit 2 o'clock, but just to wrap things up, there's one last question, which I think is a sort of general one that allows everyone to have their final say, which is really asking you, what is the name the one change that you think you'd most push for in this area? So that's from Jamison to, I guess, everyone on the panel.
I want to stop people, you know, having these interactions. So, if you're talking about after the interaction, then, full independent investigation, transparency and accountability. But ultimately you want people to stop getting to that point. And so I think we need systemic change, and we do need to have real conversations like Jeremy was talking about, and Tamar, and I know Amanda would agree too, about how do we, de-invest and, talk about de-investing in police and the criminal justice system back into community to stop, this from happening in the first place. So defund police.
Invest in people and communities, prison and police.
Yeah.
I think many better ways to spend, the current 3.4, billion budget that's just in the state of Victoria for police alone. So they're probably better funded for research than the law school is. Anyway, but I could go on forever. I'll just leave it there.
Tamar and Jeremy, do you want to add anything to that?
I agree completely with both of you. We need, if we are going to have police and we are going to have interactions, then any investigation needs to be independent, effective. Like effective is really, really critical. And as Jeremy said, with IBAC, it doesn't matter if it's an independent organisation, but it's ineffective, that's useless. So yeah, there are some really key principles about what is required for independent investigation, and they need to be far more activist than they currently are. So yeah.
I agree with all of those comments just entirely. And so I'll just add one other one just to change it up a little bit, which is I think that there needs to be a bit of a change of mindset, both in government and in the judiciary, in respect to police misconduct and in regards to police officers and I think by staying silent, and this is at the government, on a lot of this stuff, they never come out and say anything about, the most I've ever seen was recently the guy had his head stomped on in Epping. Tim, they came out and said something very mild about that, but they never come out and condone it. And I just think it's like Donald Trump in the US, look at the damage that is done by having your leaders refuse to condemn human rights abuses. And I think that needs to change. And I think if that changed, then there would be, if you start with that, then other things can change as a result of that. But I think there has to be a change of mindset there.
Mm-hmm.
Oh, look, we'd love to go on, but we're now past our time. So apologies to the half a dozen or more, maybe a dozen unanswered questions we've got on the list. That's a huge number of questions people are posting. So thanks for that. Thank you, first of all, to the three panelists, guest panelists, for attending here and participating in this class. Secondly, to Amanda for devising the whole masterclass on policing, and to the Law School for the Masterclass program. And finally, thanks to all the attendees, including those who weren't able to get their questions asked, but asked so many great questions. Thank you for that. And don't forget to vote in Amanda's poll, which will obviously turn this masterclass potentially into something a lot more in coming years at the law school. Thanks to everyone.
Thanks so much, Tamar, Crystal and Jeremy, for generously giving up your lunch break today.
Well, thanks for having us.
And for all the time in the lead up and work behind the scenes. I really appreciate it.
See.
Yeah.